Good afternoon, everybody. Thank you all for being here, the media. I've always said from my 13 years small career that the media are the gatekeepers on our constitutional rights. We appreciate you all for being here. This is an important situation that we have that's going on here today. We have filed a federal complaint approximately an hour ago. Mayor Fouts versus the Warren City Council, the Warren City Election Commission, the Macomb County City Clerk, and the City Clerk for the Warren. The 4 federal complaint count basically alleges count 1, violation of the First Amendment right of our United States Constitution to political expression and association. Count 2, violation of the Fifth Amendment of our U.S. Constitution to be free from imposition of legal disability without due process of law. Count 3, violation of the 14th Amendment to our U.S. Constitution to equal application of the laws prohibiting retroactive application of the statutes to plaintiff here, Mayor Fouts. And count 4 is a declaratory action basically saying to the federal judge to declare that the actions of the City Council of Warren are unconstitutional. The City of Warren, which Mayor Fouts has been mayor since 2007, for the last 16 years has thrived under the leadership of this mayor. The city is the 3rd largest city in the state of Michigan and the largest metro city outside the city of Detroit in the southeastern Michigan portion. Mayor Fouts has had the exceptional high approval ratings with his constituents for over the last 4 elections. In 1998, the city passed a 3-year term limit for all running for the city government. In that proposal, the ballot explicitly addressed the topic of retroactivity by providing that the limitation would begin with the term related to the elections that had occurred in November of 1995. They're very specific about that situation. The resolution passed and the city charter was amended with specific language expressly addressing retroactivity included. In 2016, the new proposal was presented to extend the mayor's term to 5 years or 20 years. 20 years, 5-year term of 4 years each, including 20 years. The ballot proposal expressly addressed retroactivity by indicating that any years or terms served prior to the amendment would be included. The proposal passed and the charter was amended. Fast forward to 2020, the defendant City Council proposed an amendment to the city charter to undo the 2016 amendment and reduce the mayoral term limit back to 3 terms. At that time in 2020, Mayor Fouts was on his 4th term. Although the defendant's council's ballot proposal included language indicating that the charter amendment would apply retroactively, the actual charter amendment that appeared on the ballot excluded language indicating that the charter amendment would apply retroactively. The charter passed, there being no language in the 2020 charter amendment that expressly stated that the 3-term limit would apply retroactively to the mayor. Mayor Fouts began undertaking to ensure that his name would appear on the ballot for the 2023 mayoral election. In addition, the defendants, election commission, county clerk, and the city clerk, all too began the process of including the mayor's name in the ballot for the 2023 elections. Thereafter, the defendant city council brought suit in the Macomb County Circuit Court in attempts to exclude the mayor from the 2023 ballot. State Judge Toya ruled in favor of the mayor and ordered that he allowed be on the ballot. Upon appeal to the Michigan Court of Appeals, in an unpublished, non-controlling decision for the state that was reversed. The city charter as it stands would only bar the mayor from running again and no other city council, but one who is not seeking election. It's self-serving to this existing city council. The law in the state and in our nation is crystal clear. Statute that intend to be applied retroactively must be very clear and unambiguous. Under our holdings of the United States Supreme Court as well as the holdings of our Michigan Supreme Court. The Michigan Court of Appeals decision, which we know they're going to argue in this particular matter, does not apply to the case's constitutional arguments, as that has not been before the Michigan Court of Appeals, and the parties as well are different in nature. Mr. Fouts was never a party in the original case before the Circuit Court and the Michigan Court of Appeals. These claims alleged that we have here are fundamental constitutional challenges unique to the mayor himself to run for office and to vote for whoever he desires, including himself. In addition, we feel under the compelling governmental interest test that the City Council's actions would not pass muster, as the law makes it clear. However slight the burden of any restriction eliminating a candidate from a ballot may appear, it must be justified by relevant and legitimate state interests sufficiently weighted to justify the limitation. The Court of Appeals misapplied the rules of retroactivity when it ruled that default is that a term applies retroactively. In strong contrast to that, new laws are to apply forward unless clearly mandated by the legislature, not as a default. The existing law is not. When you pass new law, it must be applied prospective, not by default, retroactively, unless the legislature, those that pass the law, are ultimately crystal clear that it applies retroactively. That did not happen here. We feel applying the federal mandates, the Court of Appeals decision finding that the 2020 Charter Amendment does not contain a legislative statement of retroactive application and did not affect the vested right of plaintiff to be in contrast to the federal constitutional principles. And because a state cannot provide more constitutional protections than that provided by our United States Constitution, not less, the state has misapplied the laws. We're calling upon our federal court for justice. Whether you're a supporter of Mayor Fouts or a non-supporter, opponent of Mayor Fouts, one thing is crystal clear. Our Constitution is more important than any mayoral or electoral office holding, and that Constitution must be applied equally with the same force applied to everybody, including Mayor Fouts and the City Council. That said, we are calling upon our federal court to order the following: that the 2020 ballot, as applied to Mayor Fouts, is unconstitutional and violates Mayor Fouts' constitutional rights. Order that the defendant commission, county clerk, and the city clerk directly decertify the mayoral election in the upcoming August 8th primary, and order a special election for the mayoral race only to certify Mayor Fouts' name on the ballot for said special election. We're not asking that the election city clerk or the county clerk decertify every election, just the mayoral election, so that Mr. Fouts could have a true and accurate, fair election process, which he's entitled to under our United States Constitution and our state Supreme Court's Constitution. What you see behind me here is our the AI Law team behind us. It's William Savage and others, and supporters of Mayor Fouts. A fraction of the supporters. We don't want to get. There's not a lot of room here, and Mayor Fouts himself. And I'll turn it over to Mayor Fouts at this point. Again, I ask that you please hold off questions until Mr. Mayor Fouts' comments are done. Thank you.
I have another key supporter, John Renaud. John, if you'd like to come up here. Number one, I want to thank Attorney Naveed for his willingness to take this case. It's a challenging case, but it involves constitutional rights. And when I ran for office, I didn't give up my First Amendment right, I didn't give up my Fifth Amendment right, and I didn't give up my right to run for office, nor did I give up the rights of my supporters to be able to choose who they want, including myself. Now, I would add that I attended the Judge Toya hearing, And I thought Judge Toya made it abundantly clear before those of us that were in attendance, including the Plunkett Cooney attorney, who was unable to answer Judge Toya's question about whether it is, where does it show it's retroactive? He could not answer that. And it was clear to me that Judge Toya was going to rule that I would be in the ballot because the proposal, the ballot proposal, was not constitutional according to whether it's retroactive or not. It was not clear that it was retroactive. So I thought that was it. Then, to my surprise, the Court of Appeals decided they would not hear oral arguments, even though they had heard oral arguments about our budget and about other issues. They said, no, we're not going to hear arguments. I was extremely disappointed with that because I felt that I had been denied my First Amendment right. I'd been denied my right to speak through my attorneys, and they did not give a good answer, and their opinion basically disregarded past Supreme Court precedents dealing with retroactivity, and basically they just said, well, we like term limits even though it's not there. Then, to my utter disappointment and surprise, the state Supreme Court decided they would not even hear my case. They denied me my due process. They denied me my free speech. Now, as you said, Attorney Habib, you can go on and say whatever you want to about Jim Fouts, but this is about the fact that everybody has a right to be able to exert their constitutional rights. And I do note that the council has sent out a press release today saying that they're going to go after me, or they're going to cost me money, or what have you. I have a right to my First Amendment rights, I have a right to my Fifth Amendment rights, and obviously my constitutional rights. And I'm not going to be threatened by the city council or someone else who feels I no longer have rights because I'm the mayor. I do feel this is an important issue, and part of the reason I did this is because I've had numerous supporters, including some of the people behind me, and untold others that have said, Mayor, I am disappointed that I can't vote for you. I didn't know this proposal was going to take away, because the proposal was not clear. It didn't say that this is only targeting Jim Fouts and no one else. It was an exclusive proposal to limit my right to be in the ballot. It did not include anybody else. It was definitely aimed at me, yet they didn't acknowledge that. And I would note that the maker of the motion, Mr. Green, is now running for mayor. So that being said, I do feel this is an important constitutional question that could have far-reaching repercussions, specifically since no legislative body should be able to target one person without at least acknowledging what it is. And it should have been clear. The Supreme Court has always stated, at least in past precedents, that if it's not clear, it can go forward, but it cannot be retroactive. And there's nothing to indicate it was retroactive. And that's what Judge Toya cross-examined the Plunkett Cooney attorney, who could not explain where the retroactivity was. So I thank you for your support, and I thank everybody else for their support.
Thank you, Mr. Mayor. I'm going to open it up to questions. Go on,
Mr. Mayor, you announced, well, the decision came out in May. It's almost 90 days. Why wait so long now to do this? And can you please explain what your remedy actually is?
I'm going to let my legal counsel answer that question.
Obviously, the mayor is not an attorney, and this is a legal battle in the front. And what happens is that we just recently met up with the mayor, explained the situation. Our team done extensive research. As you know, we've been doing civil rights for 23 years. I was appointed Civil Rights Commissioner years back with the Granholm administration, and we've done many civil rights cases. I know you've been in my office a number of times. The thing is that we were able to research the issue and found out that, in all sincerity, that he was wrong. He was wrong on many different levels, and so we were just recently retained to be able to bring this. So obviously, we love to have had, been appointed or been retained months ago, but unfortunately the circumstances were that he was just able to find this counsel and to move forward on it.
Would you clarify the remedy that you seek? In other words, you're looking for the mayor to be put back on the ballot for purposes of being qualified for the November election? Is that what I'm hearing?
We're looking for the mayor to be put on a special election for the primaries. We still have some time for the November 7th general election, so we're not asking for the general election to be disturbed, but just a primary election. And only on the mayor. We need to make this very clear. It's not on all city councilors, but just the mayoral election to be able to have a special election, maybe sometime mid-September, to be able to have enough time for the mayor and his team to be able to put the ads out, put the billboards out, put the signage in the front yards out, and what have you, to know that this mayor is on board, and give him his fair constitutional right to run for office.
So, quick question as a follow-up on that, please. Ballots have already gone out to people, and they have started to return those ballots. So are you asking them to basically, after Tuesday, not count any of those votes, and then to have a special election with the mayor and everybody else on at a future date?
No, we're asking that those ballots be held in abeyance until the special election is run. With those ballots, all ballots will go out, and the mayor, as well as the new ballots, will come out and have a special election for that time. So it'll be a fair election for the mayor included in this process.
And who would be on the special election? What names would appear on that?
It'll be just a mayoral election. It'll be whoever's running for mayor now, as well as Mayor Fobbs. And we know Green is running, and I don't know who else is running, but
There's a whole host of
a whole host.
So the top two vote getters that would traditionally continue on, that would just all stop. It's almost like people didn't vote for those folks, and they would have to re-vote again with all the
They
names.
would have to revote with, again, the ability to vote for Mayor Fobbs, and that is, again, special elections happens across the country. The idea is that we put those back out and see what the will of the constituents of the people of the city of Warren want as their mayor.
Do you know if those folks would automatically be carried over who are currently running with the mayor's name in addition, or would people have to file their name again, like they do for other elections?
I don't think they have to file their name again. If they're already filed, the only thing is we're asking the federal judge to put him back in the file, include him with the other other candidates that are running.
And then everybody would vote again?
Everybody will vote again for the primary, yes.
Okay, thank you.
Thank you.
The federal court system.
Just for mayor.
Okay, the federal court system moves rather slowly. Are you asking for an emergency ruling on this?
Absolutely. We've set that in our complaint due to, actually, we include a lot of law in our complaint, which normally we don't do, but because of the emergency circumstances and time is of the essence, we're also filing by probably today another expedited hearing on this complaint. As you can see, we've done this, and when I was before the redistricting lawsuit before the Michigan Supreme Court, they moved quickly. Within 20 days, we had oral arguments before the Supreme Court on the redistricting lawsuit, and that was very quickly because of the essence of the importance of the will of the people and the ability to vote for their candidate. Yes?
Attorney Nadia, Tuesday is the primary.
Yes.
Do you have enough time for Tuesday to have the decision? And if it's not, are you asking, you answer him, are you asking to extend the primary probably a week or 10 days till his cases be solved?
Thank you, Wally, MEA TV. Some forces are at play already that we can't ask them to extend the primary, so those votes will come in as the will of the people. But we're asking the federal judges to have a special election to be able to address and put Mayor Fobbs on that ballot in order for the people to vote for him coming mid-September. Again, before the general election.
Can I ask the mayor?
I'm sorry, Charlie, go ahead, I'm sorry. I'll get back to you.
I'll be short. I see in the complaint, you're also asking for money damages against Warren City Council. Why and how much money do you want?
Well, again, they're asking basically for, when you're mayor for 16 years, Charlie, and you have an expectation that you're gonna run for another 4 years, and you have supporters and people that supported you for all those years, over a decade or so, the fact is that there's money's expense. There's money's expense that you have to endure, that you're gonna lose upon what's caused, from ulcers to whatever, to know that you're gonna be without a job come November. it's a harsh feeling, and I think those individuals that are responsible, at least the law says those individuals are responsible, should pay. And in addition to attorney fees and everything else that he's entitled to under the Equal Access to Justice Act, for violating a constitutional right that this mayor has, and every person, every resident actually in the state has.
Any amount?
We're gonna let the courts decide what that amount is. Thank you.
Mr. Mayor, when we spoke back in May, you were disconsolate that the Supreme Court had ruled this way. This is apparently recent that you've been able to figure out that perhaps you can have a remedy here. Can you talk a little bit about your emotion about, one, discovering the remedy, and two, what you're doing and why here now, based on what you've been told?
I would defer to my counsel. I would just say that I did come in contact with him a few weeks ago, and we discussed things, and that's how it came about. But I'm very appreciative of him. He came up with an interpretation dealing with the court that I wasn't aware of.
Yeah, I can assure you that we do our homework. We've been doing civil rights for 23 years, from many cases that you've been in our office on. We do our homework, and if there's a remedy for them, and I told him when I first met, that if there's a remedy, we'll go after it. If something tells me that it's fundamentally in violation of our Constitution. So we've done our homework. We looked at it. We came back, presented it to him. His team looked at it, said, let's move forward on it. And that's the process.
Two quick follow-up. Mayor, I'm assuming you're paying for this on your own
Yes,
versus
right.
city funding. Also, I know you have indicated that you, at least at one of the times I've seen you, that you would be moving forward and be an advocate for the city. Clearly now you are trying to try to get on the ballot again. Can you talk a little bit about that that change in your thought process there?
I already answered that, but I'll answer it again. I've come in contact with numerous people. My executive assistant Amanda can tell you. People are constantly calling me up. I'm running into people when I'm jogging, wherever, and they're saying, why aren't you on the ballot? Many are saying, I want to write you in. I'm saying, no, you can't write me in. Well, then do something about it. So I have overwhelming feedback, support from average Warren residents who've said, I want to vote for you. What can you do? So that's part of the reason I'm doing this. I did not expect that. And so I'm appreciative of their overwhelming support.
As a follow-up, are you concerned, or do you have any comment in terms of if this is against council and other parties, that city funding or county funding will be used in this litigation in federal court? And that would be taxpayer dollars.
Well, the only taxpayer dollars going to be used by the city council themselves that we feel that violated the constitutional rights of this mayor. This mayor has a right to move forward, and the laws are crystal clear. If you're going to pass some law, it has to be prospective, and let's make it crystal clear. And this is throughout the state. Other states have addressed this, and our Supreme Court that had addressed this. It must be crystal clear that it applies retroactively. Once you start counting the terms that this mayor has basically engulfed in, you're talking about retroactivity, and you have to be crystal clear. And they weren't crystal clear. They are the ones that maneuvered this and to their benefits. Put a loophole with some of these mayors. Some of these individuals can literally run 3 terms, retire a day before their 12 years, and run again for another 12 years, and then run again for another 12 years. But this mayor cannot do it. So there is no detrimental effect to any of the city council members stating right now, except the one that is not going to be running. Okay, the side is not going to be run, but this mayor. So it is, it begs the question why. And we feel that they've done it intentionally to basically what I feel was kind of a coup to get this mayor out against his constitutional protections and constitutional rights. Charlie?
If I could just ask the mayor, I read a little bit of the complaint. Just explain in layman's terms what you really think about this city council that you believe took away your constitutional rights.
Charlie, you're good.
Charlie, I'll put it this way. I apologize if I offend somebody. I've had 4 years of help from this city council. From the time they got elected, they decided to fire the first African-American city attorney ever in history of Warren. They hassled and harassed my fire commissioner and tried to force me to fire him. He happened to be the first African-American fire commissioner. He's been with me for nearly 16 years. He's done a damn good job. They refused to reappoint another African-American woman, Jocelyn Howard, who was chairman of the Planning Commission, and they have personally insulted and harassed all of my department heads, and every week they start out with a personal gripe against me and disparaging comments and what have you. If that's not enough, ultimately, they said, we can't get him any other way, so we're going to use a TKO. We're going to come up with a way to keep him off the ballot, and that's precisely what they did, but shame on them. They didn't include retroactivity, so they tried to be too smart because of their law firm that they hired, which in my opinion is not legal either, but I don't know. Go ahead.
If you are not successful in getting what it is that you want out of this situation, what other recourse do you guys have? What's the next step?
You know, a lot of times, we're not strangers to the Sixth Circuit Court of Appeals. I mean, we're there a lot in the Ohio, and the Cincinnati, where the Sixth Circuit is located. Sometimes it does take the Sixth Circuit to decide. They're one step away from the Supreme Court. So we're hoping that the federal judge, we have Federal Judge Steve, very smart judge, senior judge in the federal court, very smart. He understands. He used to be a Macomb County actually state court judge back in the day. But he's well versed. He understands the Constitution, and we're hopeful that the federal judge is going to do the right thing in these set of circumstances. If not, we do have an appeal right to the Sixth Circuit United States Court of Appeals, and possibly to the Supreme Court of Islam.
Is there any fear that the clock could run out? Obviously, you're asking for an emergency
Right. I mean,
situation here, but even beyond that.
Yeah, I mean, you've seen, and the Supreme Court just struck down, the Alabama redistricting lawsuit. I mean, which means that they have to go back, do a redistricting, redraw their maps, and be able to have a new special election for those individuals who are affected by it. So how long does justice takes to be able to be addressed? We will wait. I mean, justice delayed is justice denied. But in all essence, at the end of the day, if justice serves, we'll be there. If it takes 6 months, a year, 2 years, the fact is that there's unfairly an effect on this mayoral candidate to deprive him of his right to run for office.
And I would just add, I appreciate the fact that you took this case, and that it finally gives me a chance to have my day in court. I just want my day in court, that's what I want. And that has been denied by the state Supreme Court and indirectly arguments by the Court of Appeals.
Any further questions?
Do you have any time frame based on your experience with the court, how quickly they could move on this?
The federal courts is like God in that courtroom. They can do what they want. So they're going to move fast. I think the Supreme Court for the redistricting, I think the Supreme Court filed all sorts of court rules and what have you, and they've done it within 20 days. So I think this federal judge can do it within the next 3 weeks. That's why we're anticipating a decision to come down by the time. We're moving quickly to serve them by tomorrow morning, so we can be fair to all parties. They can answer, go before the court. We ask for expedited hearing and to move things quickly, because again, we're not trying to hinder or affect the will of the people in the city of Warren.
And I would just add this, all I ask is let the people decide. That's all I'm asking, is to let the people of Warren decide.
And they may not vote for Mayor Fouts, but again, he has a constitutional right to be on the ballot, just like all of us. Any further questions? All right, thank you all for coming. Appreciate you.
Thank you for your support.